Can you secretly record your boss or your coworkers in Ontario? How's it going, guys? Andre Issa here, your friendly neighborhood employment lawyer, and today we're going to be talking about whether or not you can secretly record your colleagues or your boss at your workplace. Now, before we get into the video, guys, I just wanted to put a very brief legal disclaimer out there. None of what I'm about to say constitutes legal advice. It's just legal information. If you believe that you have a legal issue, you're welcome to contact me or any other lawyer in Ontario. But with that disclaimer out of the way, guys, let's jump right into it. The first point to mention is that in Ontario, we operate under a one-party consent rule. What that means is, as long as you are party to the conversation, you are allowed to record it without notifying the other parties. This is found in section 184 of the Criminal Code of Canada. Now, it's important to mention, however, that just because it's not criminal to record other parties without their permission or without notifying them that you're recording them, provided that you are a party to the conversation, the rules in the workplace get a little more specific. Specifically, just because you are a party to a conversation and you record the other party without their permission, that doesn't guarantee that you won't get fired for that, like legitimately get fired. It ultimately depends on what seems to be, according to the case law, the reasoning for why you're recording. Still confused? That's okay. I'm going to give you some examples. In this case, the employee was secretly recording his coworkers throughout the years, and when asked in court why he was secretly recording his coworkers, at one point he said that it was so that it could help him learn English. As you can imagine, the courts didn't really accept that as a legitimate reasoning for secretly recording his coworkers, and so unfortunately, because of that, the employee ended up losing his case. On the other hand, in this case, the employee also secretly recorded his employer. However, his reasoning for doing so was not to learn English. It was because he believed that his rights were being violated, and so he wanted to record his employer so that he could protect himself. And the court said that that's okay. And the employee ended up winning that case. So as you can see, between these two cases, the employees ended up doing the same thing, secret recordings, but two completely different outcomes. So why the difference? Well, it seems to be the difference lies in the reasoning for why the employee was secretly recording. One of the reasons was a illegitimate reason. It was an arbitrary reason for recording, and the other one was a legitimate reason to protect himself, to defend his rights. So you might be wondering, if there's something going on at your workplace, do you have a valid, legitimate reason to record your colleagues or your employer? Well, not to give the lawyer answer, but it ultimately depends. It depends on why, it depends on the context, and the only way you'll know for certain is if you contact an employment lawyer who can review the specific facts of your case to see whether or not you have a valid reason to secretly record your coworkers or your employer. And if so, what are the next appropriate steps to take? This has been Andre Issa, your friendly neighborhood employment lawyer. If you have any questions or concerns regarding your workplace, you're welcome to contact me. As always, guys, have a great day. Peace and love. God bless.